They do. It also wasn't in the ad that appeared next to the
Yeah.
statement I
The
sent.
main thing is, how does something become criminal in our legal system in America?
When a legislative body passes a statute.
So here's what I want you to know. Statements by political organizations are not law. And what we've tried to do yesterday was turn a pro-life group into a legislative body and tried to get you to rule on their beliefs. I think that is a dangerous thing for Americans to be asking a judge to do, whether you're on the right or the left. Here's a statement from an organization I don't particularly agree with, and I want you to pass judgment as to whether or not that's legal. The question for you would be, if some legislative body tried to criminalize this procedure, then that would be subject to litigation in court. Is that correct?
That is correct.
A case in controversy doesn't arise because you disagree with a statement of a private person or a private group. Is that correct?
That is correct.
A case in controversy arises around criminal law when somebody passes a criminal statute. Is that correct?
That's correct.
Then and only then would you determine the constitutionality of that provision. Is that correct?
Well, actually, not even then. The statute would have to be enforced against somebody, so a prosecutor would have to try to hold someone criminally liable for getting IVF, for example.
So the case in controversy concept would have to mature.
Yes, there would be quite a lot of maturation required.
Yeah, before it got to the Supreme Court, if it ever did. So I just want every American to know it's not the judge of it's not the role of a Supreme Court justice to pass judgment on your opinions. It's the role of a Supreme Court justice in very limited circumstances to pass judgment on laws passed by legislative bodies and in other circumstances, regulation, I would suppose. Now, voting. Is it appropriate for legislative bodies to protect the integrity of the ballot box?
So any specific measures that legislative bodies took to protect the integrity of the ballot box could be subject to litigation, subject to challenge.
And that's right. And as they are developed, the courts will hear cases if cases and controversies arise, right?
Yes.
One of the reasons we don't have an agreement with the House is that in their $2.2 trillion package, they're mandating ballot harvesting as a national policy. I think it's ripe for fraud. We've seen evidence of ballots being placed in people's cars and dropped in ditches. So I think there will be an effort, I hope, to protect the integrity of the ballot and also ensure easy voting. I don't think they're contrary goals for the nation. Now, when it comes to being on the court itself and collaborating with other members of the court, what's your experience been at the Seventh Circuit level? How's that played out?
It is so collegial. We all collaborate. I have the greatest respect and have had wonderful interactions with every single one of my colleagues.
Do you think you have the capability to fit in at the Supreme Court?
I hope so.
Okay. So we talked a lot about laws legalizing same-sex marriage. What's the name of the case?
Obergefell.
Okay. And you would, if anybody tried to change that precedent, one of the things you would look at is a reliance interest that people have formed around that piece of legislation?
Yes.
Same with Casey and Roe?
Yes.
Okay. So reaching a decision that the case was wrongly decided doesn't end the debate in terms of whether or not it should be repealed. Is that correct?
That is correct.
And there is a very rigorous process in place to overturn precedent?
There is many factors, reliance being one.
Okay. Is there any constitutional right to a polygamous relationship?
Let's see. That might be a question that could be litigated at, polygamy, obviously, in many places is illegal now, but that could be an issue somebody might litigate before the court at some point.
You know, somebody might make the argument it's possible for three people to love each other genuinely, and that would work its way to the court if somebody wanted to make that argument. Is that correct?
Somebody could, make that argument.
So you've been asked a lot about Roe v. Wade and Casey, and one of the differences between Brown versus Board of Education and Roe line of cases is there's active litigation regarding Roe. Is that correct?
That is correct.
I think Senator Hirano named 8 or 9 different cases that may come up to the court, cases in controversy. And one of the reasons you can't tell us how you would rule is because there's active litigation coming to the court. Is that correct?
That is correct.
And one of the reasons you can say with confidence that you think Brown versus Board of Education is super precedent is that you're not aware of any effort to go back to the good old days of segregation by a legislative body. Is that correct?
That is correct. And I've also said that in lectures that Brown was correct as an original matter. So that is the kind of thing, since I've said it in writing, I felt like I could express before the committee.
When it comes to Heller, there's legislative bodies all over the country passing laws regarding gun ownership. Are you aware of that?
I am aware of that.
Okay, when it comes to Citizens United, I think there'll be some efforts after this election to maybe revisit that case. So the thing that I'm trying to establish here is that Heller, Citizens United, Roe, Casey are all actively being litigated because legislative bodies are playing in that arena. Is that a fair statement?
That's a fair statement.
So your point to us is when it's likely that case and controversies around the holding of a particular case are going to come to the court, there's only so much you can tell us about what you may or may not do.
Absolutely.
So that Roe v. Wade compared to Brown versus Board of Education is not super precedent.
Not super precedent, as I was using that term in the articles that have been referred to.
And let me tell you from a common sense point of view why it's not super precedent. I have legislation. 14 states have passed a law that I'm trying to get passed up here, that in the 5th month of pregnancy, 20 weeks, an unborn child is capable of feeling pain. I'm making the argument there's a compelling state interest to protect that unborn child from a very painful death called abortion. There's only 7 nations on the entire planet that allow abortion on demand in the 5th month. Now, that's a political exercise we're going through. 14 states have passed a version of what I've just described. That will be coming to the court, I would imagine, in the future. All I ask is that will you listen to both sides of the argument if it gets to you?
I will.
Thank you. Judge, all I can say, I've met a lot of people in this business and very impressive people. One of the highlights of my time on the committee is to get to meet incredibly talented, smart, squared-away people. Justice Roberts sat right before you and didn't have a note. A lot of people on my side are upset with him about this or that. Sometimes I disagree with him, but I do know this, that he's doing what he thinks is best for the court and for the country. Justice Sotomayor and Kagan, delightful people, incredibly wickedly smart. Justice Kagan had a biting sense of humor, and they're on the court because they should be. They're on the court because they live lives worthy of being on the court. They're on the court because they're some of the smartest people in the land about the law. They're on the court because they lived incredibly productive and meaningful lives. Justice Gorsuch and Kavanaugh are both on the court for the same reasons. As to you, you're every bit in their league. In my view, this is exactly where you should be going to the Supreme Court, that the United States of America will benefit from your participation at the Supreme Court. You will offer a point of view that millions of Americans share. You will have life experiences that will round out the court. You will apply the law to the facts, and that you are going to inspire a lot of young women, just like Justice Ginsburg did, just like Justice Sotomayor and Kagan did, and the young women that you're going to inspire don't have a whole lot of role models they can point to in terms of the media world in which we live in, uplifting them. That's about to change. To my Democratic colleagues, I understand where you're coming from. I understand what you want the court to do. You want the court to do things differently than we do. I don't question your motives, and I want to thank you for conducting this hearing in a way that has been respectful, has been challenging, and the process will be moving forward here. And from the committee's point of view, I think we're on track to do it in a way that hopefully people will say, even though you disagree strongly, you're not that disagreeable. Senator Feinstein.
Thanks very much, Mr. Chairman. Judge, I must say, I'm delighted to see your family here again, and I hope they feel that very special sense of pride in you. I'm sure they do. And I think, I was thinking of my children and grandchildren, and this is really a once-in-a-lifetime occasion. So I hope they find it very special in their lives.
Thank you, Senator.
You're welcome. Yesterday, you spoke of California v. Texas, the current case seeking to strike down the Affordable Care Act. You said, I think, that the issue before the court is severability, meaning whether the court can still uphold the Affordable Care Act if it rules that the individual mandate is unconstitutional. And you said yesterday this question was not before the court. As I understand this, Chief Justice Roberts and the majority did involve the issue of severability in a case known as the NFIB, National Federation of Independent Business v. Sebelius. There, the Chief Justice and the 5-4 majority that included Justice Ginsburg struck down one part of the law, the Medicaid expansion provision, but allowed the rest of the law to stand because they found it was severable from the portion they struck down. Justice Scalia dissented from this conclusion, stated that, quote, the unconstitutionality of the individual mandate and the Medicaid expansion requires the invalidation of the Affordable Care Act's other provisions, end quote. In other words, the justice believed that the law was not severable and the entire law had to be struck down, including provisions protecting people with pre-existing conditions. You have been close to the justice's philosophy, and in these hearings, you've also said that this doesn't mean you would reach all the same conclusions. So can you explain to us today how you would disagree or agree with Justice Scalia's view of severability in that NFIB, National Federation of Independent Business case?
Well, what I think I can say without expressing disagreement or agreement for the reasons I said yesterday, not being able to grade precedents. The severability issue, first of all, the majority holding, as you recognized, was that even though the Medicaid provision was unconstitutional, it was severable. So Justice Scalia expressed his view in dissent. Even by Justice Scalia's view, the issue would be different in California versus Texas for two reasons. One, Justice Scalia thought two provisions of the Constitution were unconstitutional. So if you picture severability being like a Jenga game, it's kind of if you pull one out, can you pull it out while it all stands? Or if you pull two out, will it still stand? So Justice Scalia, his view was that if you pulled those two provisions out, could it still stand? And here we're talking about one. And also, Congress has amended the statute since NFIB versus Sebelius, and it's zeroed out the mandate. So now, California versus Texas involves a different provision because of the zeroing out that was done by amendment. So that's how the two cases present slightly different issues.
What do you think of all that?
What do I think of severability? Or
in that instance?
I think the doctrine of severability, as it's been described by the court, serves a valuable function of trying not to undo your work when you wouldn't want a court to undo your work. Severability strives to look at a statute as a whole and say, would Congress have considered this provision so vital that kind of in the Jenga game, pulling it out, Congress wouldn't want the statute anymore. So it's designed to effectuate your intent. But, severability is designed to say, well, would Congress still want the statute to stand even with this provision gone? Would Congress have still passed the same statute without it? So I think insofar as it tries to effectuate what Congress would have wanted, it's the court and Congress working hand in hand.
Thank you. That's quite a definition. I'm really impressed. Thank you. Some have argued that the Medicare program is unconstitutional because, it's an unconstitutional exercise in congressional spending power. They believe that the spending power does not exist at all. In talking about Medicare and Social Security, Professor Mike Rappaport of the University of San Diego Law wrote this: "It is worth remembering that these programs would never have taken their pernicious form if the Constitution's original meaning had been followed in the first place." Do you agree with originalists who say that the Medicare program is unconstitutional? And if so, why?
I'm not familiar with that article by Professor Rappaport, so I don't know what reasoning he advances for claiming that the spending power as exercised in things like the Medicaid provision would be unconstitutional.
Well, it's in Law and Liberty, July 23rd, 2015. But the question is, do you agree with originalists who say that the Medicare program is unconstitutional?
Well, let's see. So I think I can't answer that question in the abstract, because as we've talked about, the no hints, no forecasts, no previews rule. I also don't know what the arguments would be. So I assume Professor Rappaport lays out a case, but it's not a question that I've ever considered before. But if I did consider it, it would be in the context of an actual case or controversy.
Well, I thank you. It's hard for me to believe that that's a real question because I think the Medicare program is really sacrosanct in this country. But let me ask you, last April, in the midst of the COVID-19 pandemic, the Supreme Court prevented Wisconsin from implementing a district court order that would have extended the state's deadline for submitting absentee ballots. This would have given voters greater flexibility in casting absentee ballots for Wisconsin's primary election. Justice Ginsburg dissented. She criticized the court's majority for putting its head in the sand with regard to the risks posed by COVID-19. She emphasized that courts and election officials must be able to react to a grave, rapidly developing public health crisis. And she noted that the Supreme Court's, quote, suggestion that the current situation is not substantially different from an ordinary election boggles the mind, end quote. Would you agree, and what is your position?
Well, Senator Feinstein, that's obviously a very recent case. And, in that case, the court had to address, the constitutional question. And so, again, it's one of those things that I can't answer, both because it would be requiring me to grade and express agreement or disagreement with the Supreme Court opinion, but also it's the kind of case that could come up in a closely related form, either on the Seventh Circuit, Wisconsin is within the Seventh Circuit's jurisdiction, or on the Supreme Court.
Okay, let me try again with something. After President Trump announced your nomination to the Supreme Court, you discussed the judicial philosophy of the late Justice Antonin Scalia. Specifically, you stated, his judicial philosophy is mine. During oral arguments in the 2013 case Shelby County v. Holder, Justice Scalia questioned the strong congressional support for reenactment of the Voting Rights Act. He argued that this support was not attributable to the fact that we need the Voting Rights Act. Rather, he stated that he believed Congress reenacted the bill due to a, quote, phenomenon that's called perpetuation of racial entitlement, end quote. What is your reading of this and your understanding of the history of the Voting Rights Act?
Well, When I said that Justice Scalia's philosophy is mine too, I certainly didn't mean to say that every sentence that came out of Justice Scalia's mouth or every sentence that he wrote is one that I would agree with. When I said Justice Scalia's philosophy is mine too, what I meant is that his jurisprudential approach to text, as we've talked about originalism and textualism, is the same that I would take. And I think as for the Voting Rights Act, I think that it was obviously a triumph in the civil rights movement.
Well, the question arises in my mind. Of course, my view is that we always need this. This is a bulwark of our democracy. So need, I think, is something that may be somewhat subjective. Do you agree with that?
That need is subjective?
Yes, yeah, that I think we do need a Voting Rights Act, and it's subjective in that sense.
Well, I think Senator Feinstein, the question of how the coverage formula is calculated in the Voting Rights Act and the contours of the Voting Rights Act and whether Shelby County was rightly decided or not are all questions on which I can't give an answer because Shelby County has obviously been controversial. It's likely to be relitigated. It could come up before me on the court.
Well, let me give you, because I think this is really important because it shows the basic philosophical bent of an individual. For me, the Voting Rights Act is extremely important, and it defines our election system to a great extent. It's hard for me to understand that anyone would want to do away with it. What is your position in that regard?
As I understand Shelby County, it said that the coverage formula was outdated from the 1960s for subjecting the particular states, requiring them to get preclearance. It's my understanding, and I haven't looked at the case in a while, that everything else about the Voting Rights Act remained intact, including its prohibitions on discrimination in elections. It was just the coverage formula which decided which states were subject to preclearance.
Well, let me ask you this question, and this is a hard one. Do you agree with Justice Scalia's assertion that the Voting Rights Act is a, quote, perpetuation of racial entitlement, end quote?
Senator Feinstein, I don't obviously know what Justice Scalia was thinking when he said that. And any characterization of the Voting Rights Act or a statement like that is simply really not something I can opine on because, you know, that's tied in, I would think, with these Shelby County questions.
Well, can you opine? I'm not asking for a formal opinion, but would you believe that it's a perpetuation of racial entitlement?
Well, Senator Feinstein, I think that goes to the question of whether the coverage formula was outdated and needed to be updated from the 1960s or not. I take that to be the thrust of the disagreement in Shelby County and the position that Justice Scalia was taking. So again, I can't express a view on Shelby County and whether the majority or dissent had the better of the argument.
Okay, let me move on to workers' rights and age discrimination. In a 2019 case, Kleber v. CareFusion Corporation, you joined a majority of the Seventh Circuit judges in holding that age discrimination in employment does not protect job applicants against employment practices that have a disproportionately harmful impact on older applicants. The opinion you joined, as I understand it, dismissed a claim brought by a 58-year-old lawyer who was passed over for a job that was offered to a 29-year-old applicant with less experience. I think I'm concerned by the implications of the decision. According to AARP, approximately 35% of the United States population is now 50 years or older. Almost 29% of households are headed by someone near or past retirement age who have no savings or pension. According to the EEOC, Study after study has shown age discrimination, quote, remains a significant barrier for older workers, end quote. And older applicants are more frequently denied job interviews than middle-aged applicants. Additionally, older and middle-aged women are subjected to more age discrimination than men. The EEOC has found that the Great Recession during President Bush's administration, quote, forced many older workers to revive their retirement plans, to work longer to recoup drained retirement accounts and lost savings. So here's the question, because I think it's going to be an increasing problem for the court. What do you understand to be the purpose of age discrimination, of the Age Discrimination in Employment Act?
Well, in Kleber versus Care Fusion, I joined a majority of the en banc court, so that was a case that we heard as a full court. And the question is whether the prohibition on age discrimination covered applicants or only employees. And the statute said employees, and so an applicant isn't an employee. So the majority said that the statute, by its terms, didn't cover the conduct. But I think that's an instance, I talked yesterday quite a bit about whose role it is to update statutes or extend them, and I think that's an instance in which Congress could well address this problem by amending the statute to include applicants in it.
So where would you stand on the general subject matter?
Well, since I can't impose the law of Amy, that would be up to the Congress to decide, or many state legislatures have different anti-discrimination prohibitions that offer even more protection than some federal statutes.
Okay. Let's talk for a moment. In 2013, you wrote, and this is a quote, I tend to agree with those who say that a justice's duty is to the Constitution, and that it's thus more legitimate for her to enforce her best understanding of the Constitution rather than a precedent she thinks clearly conflicts with it. If you are presented with a case where your view of the Constitution conflicts with Supreme Court precedent, what will control your decision? Your understanding of the Constitution or precedent?
Senator Feinstein, I'm really glad that you brought that up because that quote was mentioned a lot yesterday, and I'm happy to have an opportunity to explain the context. That entire article, I think that there's been some misunderstanding perhaps because that sentence, first of all, it was citing a footnote to both an originalist scholar and a progressive constitutionalist. But the whole article was defending the Supreme Court's current doctrine, which accords constitutional precedent weaker stare decisis effect than, say, statutory precedent. And I mentioned that yesterday. Against claims that we should have no doctrine of stare decisis at all, and against claims that it should be absolute and completely tie the court's hands. So I actually wasn't arguing for any alteration to stare decisis doctrine. I was saying this is how it is, this is how the Supreme Court does it, and that's right. And another couple of sentences in there, which I think might put my perspective in context, I said a new majority cannot impose its vision only with votes. It must, now I'm paraphrasing myself, it must be very sure that its interpretation of the Constitution is the right one and that reliance, interests, etc., don't counsel in favor of its overruling, paraphrased. And then the next sentence was something to the effect of, an uncertainty in that regard counsels in favor of preserving the status quo. So that sentence, if it's just read alone, makes it sound like I'm arguing for the overthrow of stare decisis in constitutional cases altogether, but that wasn't the thrust of the article, quite to the contrary.
Thank you. Thank you very much. And we all welcome the fact that your family's here. It's a beautiful family.
Thank you so
Take care,
much.
everybody. Thanks,
Thank you,
Mr.
Senator.
Chairman.
Thank you very much. Senator Grassley. Don't stop, don't start the clock yet. He's not ready. For $5, I won't start the clock.
Judge,
Start the clock.
welcome back.
Thank you, Senator.
I want to compliment you for doing a very good job answering our questions and all about your decision-making process. You've been forthright, candid, thoughtful. You've demonstrated a tremendous command of and respect for the law and Constitution. You've shown us that your judicial method is rigorous, but also fair and open-minded. Above all, it's clear that you understand the appropriate role of a judge, just what we're looking for, at least on this side of the aisle. An individual who will interpret the law, not one to make it. You are an outstanding candidate. A couple things before I ask my questions. First, Judge, many of my colleagues on the other side have tried to get you to tell us how you rule on a case, whether you believe a case was correctly decided, or whether you'll commit to uphold a specific law. As you've responded, it is not appropriate for you or any nominee in your position, for any level of the judiciary, to make promises or give hints on how you'd rule or what you think about a potential issue that may come up. Judicial independence from the legislative and executive branch, those are our political branches accountable to the people, is a bedrock principle of our constitutional system. Justice Ginsburg said it best: a judge is sworn to decide impartially and can offer no forecasts or hints, because that would show disregard for a particular case. And she also said you can't display disdain, or it would display disdain for the entire judicial process. You testified that you have not made any promises to anyone about how you might rule on a case that might come before you. That's because you know that a judicial nominee should never promise votes in exchange for a president's nomination or a senator's support. Moreover, we saw yesterday, and to some extent Monday, Democrats' strategy continues to be to use scare tactics, distortions, and speculation. They're framing you as a real threat to health care coverage, and especially protections for existing conditions. This is all a charade. Just because of your comment, I believe just from one law review article you wrote, critiquing Chief Justice Roberts' reasoning. So it's time to get real. This is all just a distraction. This is what we saw Monday and Tuesday. Democrats want to distract from the fact that they don't really care about Obamacare. You heard that since Democrats started their presidential primaries probably about 2 years ago. They want government-run Medicare for all. That's what you heard in the Democrat primary. The changes they seek to the ACA move America closer to a single-payer system where the government provides or subsidizes health care for all Americans, which we know eventually leads to government rationing of health care. Democrats want to distract from the fact that they just filibustered a COVID relief bill that would have protected pre-existing conditions. Next Monday, we'll see if they'll vote for a COVID recovery bill that Leader McConnell has scheduled for a vote next week. Democrats want to distract from the fact that Republicans, yes, Republicans, have introduced bills to protect Americans with pre-existing conditions and to bring down drug prices. And if we act, they don't have to worry about you doing away with pre-existing conditions in some future case down the road. In fact, given the opportunity to advance bipartisan Prescription Drug Pricing Reduction Act, that's the Grassley-Wyden bill, Democrats at Schumer's command walked away because they wanted an election year issue. Republicans passed and signed into law bills to end pharmacy gag clauses and to end abusive drug tactics that prevent lower-cost generic drugs from coming to market. Democrats want to distract from the fact that President Trump and the administration have taken steps to help lower health care costs for Americans, including finalizing a rule to allow the importation of prescription drugs from Canada and proposing a rule to facilitate the purchase of affordable insulin and EpiPen for lower-income Americans. The president has signed an executive order to end surprise billing. Further, I and other Republicans have been working with the administration to increase transparency in drug prices, to step up enforcement of anti-competitive activity and prosecution of bad actors in the healthcare industry, and to improve and expedite regulatory approval of drugs to combat COVID and other diseases. Here is the bottom line of what we've all heard Monday and Tuesday. The Democrats cry foul over anything that may help Americans if it doesn't advance their agenda for Medicare for all. And the American people deserve to be reminded of this hearing what it's all about. It's all about your qualifications to be on the Supreme Court. It's not about health care advocacy. Finally, Judge, Democrats want to distract from the fact that you're eminently qualified for this position you've been nominated for. And they don't like it that you know that the place of the courts is not to rewrite laws as you might see fit there. Here's the bottom line. I've asked you yesterday if it's your agenda to repeal the Affordable Care Act. You said, quote unquote, absolutely not. You said you've never made a commitment to anyone on the Affordable Care Act or on any matter. You've never been asked to make such a commitment. And you made very clear you would never make such a commitment. Mr. Chairman, I want to put some letters in the record from state legislative leaders supporting this nominee.
Without objection.
Now, you won't get away with asking some questions on some things that I'm very interested in. I'd like to discuss a law that I brought up with you when we talked for a short period of time, one-on-one. We didn't discuss it at that time, the False Claims Act. In 1986, we passed legislation that I drafted to make False Claims Act an effective tool to combat fraud against federal programs. This law enlisted the help of private citizens to enforce the False Claims Act through qui tam lawsuits. In 2000, the Supreme Court deemed the false claims qui tam provisions constitutional. As you know, the False Claims Act has emerged as the government's primary weapon against fraud. Since we restored the law in 1986, false claims actions have recovered $68 billion of taxpayers' money fraudulently taken, with $50 billion coming from whistleblower-initiated actions. Congress has remained vigilant to protect the False Claims Act from attempts to weaken it in the courts. Have you ever written or spoken publicly about the constitutionality of qui tam or any other provisions of the False Claims Act? And if so, what were the circumstances or the context?
Senator Grassley, I don't recall ever speaking about the False Claims Act or the constitutionality of the qui tam provisions or any other part of the act. So I can't think of a time when I have.
Do you have any preconceived ideas about the False Claims Act or Whistleblower Protection Act that would impact your ability to impartially decide any cases involving those issues?
I do not. Any case involving that act, I would approach with an open mind as with any other.
Some opponents of the False Claims Act argue that qui tam provisions are unconstitutional under Article 2 and 3. Are you familiar with these legal arguments? And if so, do you have an opinion on them?
Are you talking about the qui tam challenges?
Yeah.
Well, those aren't ones that I can express an opinion on because, as you say, they've been up before the court.
Another interest of mine that I probably at 87 years of age won't live long enough to see done, but I've discussed cameras in the courtroom and introduced legislation on that over the last 15 years. It's not a very popular subject. Judge Souter joked that he'd have to roll over in his dead body before they'd put cameras on the Supreme Court. While I can respect that point of view, I totally disagree. Many of us believe that allowing cameras in the courtroom would open the courts to the public and bring about a better understanding of the judiciary. For many years, that bill that I've introduced has been called the Sunshine in the Courtroom Act, a bill to give judges the discretion to allow media coverage of federal court proceedings. I'm also a co-sponsor of Senator Durbin's bill to allow cameras in the Supreme Court. I understand that the Seventh Circuit Court of Appeals, where you currently serve, adopted procedures to allow requests for video recording of oral arguments as well as public release of the recordings.
That's correct.
Has your court had any problems with these procedures? What are your views on allowing cameras in the courtroom? If confirmed, would you keep an open mind about allowing cameras in the Supreme Court?
I would certainly keep an open mind about allowing cameras in the Supreme Court.
I always ask people, district, circuit, or Supreme Court, this question about international law. I'd like to get your views on how and when you would apply international law to your decision-making process. Is it ever appropriate to cite international law when interpreting the U.S. Constitution?
Well, I would never want to say never because it's certainly possible. Generally speaking, so it's been applied in the issues with which foreign law has been applied, and there's a debate about it, are when we're trying, or when the court is trying, or lower court is trying, to identify what is the nature of a right that's part of the tradition of the people, or that the people, like what would the people view? And in my view, the United States Constitution is a compact, and it's the fundamental law of the American people. And so I don't think it would be controlled by the laws passed by other countries because it reflects the fundamental commitments that we as an American people have made.
Thank you very much. I reserve my time.
Senator Durbin. Oh, I'm sorry. I apologize, Senator Lee. Apologize.
I'd kind of like to get
Yeah, no, out of sight, out of mind. I apologize.
Okay. Thank you. Can you hear me all right?
Yes, sir. Loud and clear.
It incidentally, for those who are watching and think that we may be polarized in things, and listen to what Senator Grassley said about cameras in the courtroom, and of course I agree with him on that, and he knows I supported that. I've also joined with him in a few of the False Claim Act improvements. So there are many areas in our committee where senators have worked together. And I would ask, Mr. Chairman, if I could, unanimous consent, that a letter from 10 former federal judges were opposed to the process of this nomination, along with letters of opposition to the nomination from People for the American Way, NARAL, and 208 women lawyers, that they be inserted in the record.
Without objection.
You have to assume somebody's going to hand you those letters. I can't quite reach from my room here. Now, Judge Barrett, it's good to see you again. I commend your children. I'm sure this is fascinating, but I'm sure it's a long day. And I'm sure you probably felt the same way, but this is part of democracy, and it's important that we have these questions. Now, we're being told that no one could possibly know how you would rule in the latest Republican-led case to overturn the Affordable Care Act. But what we do know is that you criticized Chief Justice Roberts' opinion in NFIB versus Sebelius. You stated that, quote, Roberts pushed the ACA beyond its plausible meaning to save the statute. And then you praised the dissent in King versus Burwell. So it seems every time you've weighed in on the legality of the statute, you come to one conclusion. The Affordable Care Act is unconstitutional. Now, over the past 2 weeks, you provided this committee, all of us, with some 1,800 pages of your writings and speeches for us to review, and I have. Now, I may have missed something in that, but did you ever write or speak out in defense of the ACA?
Senator Leahy, I just wanted to make one correction. King versus Burwell wasn't a case about whether the Affordable Care Act was constitutional or not. That one was purely a question of statutory interpretation. So just to make clear about that. I
But you
would
did
say
praise
that
the dissent. You did praise the
I
dissent, not
did.
the finding.
I did. In a
Thank you.
radio interview, I said that I thought the dissent had the better of the statutory interpretation argument. I have a couple of things, I guess, that maybe might help shed some light on this question. One is that, of course, in both of those contexts, I was speaking as an academic. And as I mentioned yesterday, an academic serves a very different function than a judge. So an academic doesn't go through the judicial process, doesn't hear the case or controversy, have the litigants and the briefs and the consultation with colleagues, the writing
Judge,
of an opinion.
We all understand that, but that's not my question. My question was, did you ever write or speak out in defense of the ACA, whether as a academic or as a member of the judiciary? That's a pretty simple question.
No.
Could be answered yes or no.
No, I've never had occasion to speak
Thank
on
you.
the policy question.
And so every time you've weighed in on it, you said the law is unconstitutional. Now,
No. Sorry, I thought you were done.
well, and the court, of course, have to it's going to have to look at both severability, standing, constitutionality, and you haven't written on severability of the ACA, have you?
I have not.
Thank you. And now, here's a quote that I'm sure you're familiar with in preparing for this, and it's been used in the last few days. Quote is, throwing out pre-clearance when it has worked and is continuing to work to stop discriminatory changes is like throwing away your umbrella in a rainstorm because you're not getting wet. Have you heard that quote before?
I believe that's from the dissent in Shelby County.
By Justice Ginsburg, is that correct?
I believe so.
Actually, it is. She was talking about and warning about striking down Section 5 of the Voting Rights Act. Now, Shelby County, it was almost like immediately after Shelby County came down, states started making changes. 20 states enacted new restrictions on voting. And some of those restrictions have been horrendous. Do you know how many polling places have arbitrarily been closed across the country since the Shelby decision?
I do not know, Senator Leahy.
I'll help you there. It's at least 1,600. Now, following the Shelby decision, do you know how many voters were purged from voting rolls?
I do not know.
Roughly 16 million. That's about 30 times the population of my state. African Americans with felonies are 4 times more likely to be disenfranchised than other Americans with felony convictions. And non-white voters are 7 times more likely to wait in line for more than an hour than, black voters wait longer in line than white voters. I mention this because this is a picture from DeKalb County, Georgia. Those are the lines. African Americans make up the majority. Look at that line. I suspect neither you nor I have ever had to wait in line like that to vote. In fact, the press reported that today those lines could be 10 hours long. People talked about, well, are we giving racial entitlement? This is not entitlement for any Americans. This is not entitlement. This is turning our back on democracy. This is saying you can't vote, or we're going to make it so difficult for you to vote, you can't. Harris County in Texas, which has population many times that of my state, has 1 early voting spot. People have to drive for hours and wait in line for hours to get there. Would you accept the fact, or would you acknowledge the fact that communities of color disproportionately face restrictions and obstacles when they are casting their ballots?
Senator, I wasn't aware of the statistics that you were citing to me. If it became relevant in any case that was litigated before me and was presented to me, I would, of course, have an open mind about it.
Well, I talk about this because I know you have spoken feeling much like former Justice Scalia, who I would note was a friend of mine. But I disagreed with him on many things. He talked about racial entitlement. It's not racial entitlement when blacks have to stand in line for 10 hours to vote. And Justice Ginsburg, of course, dissented in Shelby. She knew what the consequences would be. I only mention that because it's okay for a judge not to close his or her eyes to reality. Now, I asked you last week what a Justice Barrett would do if a president or even a senator did not follow a Supreme Court decision. You declined. You said the question may come before you. I then asked if the Supreme Court would have the final word. You stated the Supreme Court would have the final word as far as the lower courts are concerned. And that surprised me, and it concerned me, and I'll tell you why. I asked Justice Gorsuch, and I asked Justice Kavanaugh those questions. I asked them what happens then, and they made it clear that a president cannot refuse to comply with a court order, and the Supreme Court's word is the final word on that matter. That's what Justice Gorsuch and Justice Kavanaugh said. So I would ask you this. Do you agree that a president must follow a court order and the Supreme Court's word is final? Or is the Supreme Court's word only final as far as the lower courts are concerned?
Senator Leahy, I'm glad to have the opportunity to clarify from our conversation. First, I know that both Justices Gorsuch and Kavanaugh said that no man is above the law, and I agree with that. But I conversed with Senator Lee yesterday about Federalist 78, which says that courts have neither force nor will. In other words, we can't do anything to enforce our own judgments. And so what I meant in the conversation with you is that as a matter of law, the Supreme Court may have the final word, but the Supreme Court lacks control over what happens after that. The Supreme Court and any federal court has no power, no force, and no will, so it relies on the other branches to react to its judgments accordingly.
I remember as a young law student having lunch. Our honor society at Georgetown was able to have lunch with the members of the Supreme Court. I sat with Justice Hugo Black. He told me what happened with Brown versus Board of Education. And the court knew that was going to be a very, very tough case. And what did they do? They waited till they had a unanimous opinion because they knew that the president would have to, and the Congress would have to enforce their law. So let me ask you this. Of course, the Supreme Court has no army. They have no force, but they do have the force of law. And is a president who refuses to comply with a court order a threat to our constitutional system of checks and balances?
Senator Leahy, I think the example of Brown is a perfect one in this instance because the Supreme Court in Brown, of course, held that segregation violated the Equal Protection Clause. That was the law, but as you know, there was resistance to that decision. And so it wasn't until the National Guard came in and forced Governor Falbus to allow desegregation that it could happen because the Supreme Court couldn't do so itself. And in Cooper versus...
I understand that, but they made the order. And could a president, if a president refused to follow what they had said, would that be a threat to our constitutional form of government?
Well, as I said, the Supreme Court can't control whether or not the president obeys. Abraham Lincoln once disobeyed an order during the Civil War of a circuit court. So a court can pronounce the law and issue a judgment, but it lacks control over how the political branches respond to it.
Well, then let me ask you a specific that has come up. President Trump claims he has a absolute right to pardon himself. Now, for 200 years, the Supreme Court has recognized the common law principle that nobody can be a judge in their own case. I had to go way back and reread Calder versus Bull to see that. But would you agree, first, that nobody is above the law? Not the president, not you, not me. Is that correct?
I agree, no one is above the law.
And does a president have an absolute right to pardon himself for a crime? I mean, we heard this question after President Nixon's impeachment.
Senator Leahy, so far as I know, that question has never been litigated. That question has never arisen. That question may or may not arise, but it's one that calls for legal analysis of what the scope of the pardon power is. So because it would be opining on an open question when I haven't gone through the judicial process to decide it, it's not one on which I can offer a view.
Okay, and so, but you were willing to say that no person, not you, not me, not a president, is above the law. I find your answers somewhat incompatible, but those are your answers. You have a right to say what you want. Now, you're an originalist. Can you explain why the framers include the foreign and domestic emoluments clause in the Constitution?
I think I could speak generally to what is the well-accepted view that the Foreign Emoluments Clause, it's plain from that text, that it's designed to prevent foreign influence in government affairs.
It's sort of the anti-corruption clause of the Constitution, isn't it?
I'm sorry, could you repeat that question?
It is sort of what you would say that it's the anti-corruption clause in the Constitution.
I don't know if I would characterize it as an anti-corruption clause. I think I would characterize it just as I did, which one, from its very text, you can see is designed to prevent foreign countries from having influence.
I was thinking of what at the Constitutional Convention, Governor Edmund Randolph said the clause was thought proper in order to exclude corruption and foreign influence, prohibit anyone in office from receiving or holding any emoluments from foreign states. And now we find that 200 companies and foreign governments have patronized Trump properties. At the same time, they were getting benefits from him and the administration. First 2 years of his presidency, he earned $73 million from his properties abroad. And an originalist, as you are, do you think these companies and foreign governments would have fallen within the framers' zone of concern in writing the emolument clause?
Senator, the Emoluments Clause, it's under litigation. There was a Fourth Circuit case that recently involved this question. So as a matter that's being litigated, it's very clear that that would be one that I can't express an opinion on because it could come before me.
I've found it interesting what you've written about stare decisis and precedent, and it seems that you're willing to depart from it, and that's as a justice, I suppose you could do what you want, but in the June medical services, Chief Justice Roberts joined the majority, struck down a Louisiana law restricting access to reproductive services, even though he had dissented in a previous case, striking down a very similar Texas law. And he said the legal doctrine of stare decisis requires us, absent special circumstances, to treat cases alike. So having been on the losing side in the first one, he took that position of that case. Do you agree that he demonstrated a commitment to stare decisis in this case?
Well, Senator, no justice that I'm aware of throughout history has ever maintained the position that overruling a case is never appropriate. As you probably know, there's a Supreme Court case that said that states could criminalize sexual conduct between same-sex couples, and Lawrence versus Texas overruled that case. Plessy versus Ferguson was precedent, and Brown versus the Board of Education overruled it. So the Supreme Court has always said that in some cases, overruling precedent is the right course for the court to take, but that it's not done willy-nilly.
I would urge you to read what Chief Justice Roberts said at the opening of the African American Museum in the Smithsonian about following precedent. I realize my time is up. I'm going to, I'll submit a question to you because I wonder what restrictions you see on the President's authority under Executive Order 12333 to conduct surveillance activities that haven't been authorized by Congress. I ask that because Senator Lee and I and others have done a lot of legislation on surveillance, and now we question whether that's being ignored. So I hope you will take it as a serious question and answer it for the committee.
Thank you, Senator Leahy.
Thank you. We'll make sure that happens, Senator Leahy. Senator Cornyn.
Mr. Chairman, I'd ask unanimous consent that 3 letters I have here in my hand be made part of the record, please.
Without objection.
Thank you. Good morning, Judge.
Good morning, Senator.
I'd like to wax philosophical with you for a few minutes, and you don't need your notepad for this either. I just think there's been so much discussion about the role of judges and the role of the political branches. I think maybe it's worth going back to first principles. And to me, the most important first principle is in the Declaration of Independence, where it says, "We hold these truths to be self-evident, that all men are created equal, that they are endowed by their Creator with certain unalienable rights, that among these are life, liberty, and the pursuit of happiness, that to secure these rights, governments are instituted among men," and here's the most important part I want to emphasize, "deriving their just powers from the consent of the governed." Now, you and I talked a little bit about consent of the governed as being the very foundation of the legitimacy of government action. Do you agree with that?
I do agree with that.
And does that inform your philosophy when it comes to the appropriate role of judges and the political branches like the Congress?
Yes, it does.
I had the great privilege of serving on the state court bench for 13 years. And so when I came to Congress, I'd never served in the legislature before. And so it was quite an eye-opening experience for me. For example, after one vote on the Senate floor, after the vote was over, one senator got to the microphone. He said, "Now for a little legislative history." That was kind of shocking to me, but you understand where I'm getting at. And one reason I appreciate your approach and Justice Scalia's approach to statutory interpretation and emphasis on the text rather than legislative history, this is a way for somebody who lost the vote to come in and try to then tilt the scales of justice in their favor by adding some ex parte legislative history. And then imagine my shock when I served, as I do now, on the Finance Committee. When we mark up legislation in the Finance Committee, we don't actually get to look at legislative text. It's kind of surreal. They call it a notional markup. In other words, we end up voting on sort of a notion or concept, and then somebody in the Leg Counsel's office writes up the text. Very strange. And then there's this issue of, I know in the judiciary and in the legal profession generally, there's been a big movement toward plain language so people can understand clearly. You have to unlearn some of the lessons you learned in law school, particularly writing on law reviews and the like, where you are seemingly are rewarded for this really obtuse, impenetrable language, and of course, where you use Latin phrases and things like that. But the plain language movement in the legal profession strikes me as a very important movement, and I yearn for those days when perhaps Congress can embrace that so we can speak more clearly, so more people can understand and not delegate our legislative responsibilities to staff. But I also was struck by the fact that one of the reasons why cases get litigated is because of the failure of the Congress to build consensus for legislation. And to me, the Affordable Care Act is one example of that. When either side pushes through a partisan piece of legislation, it's not realistic to expect that the fight will be over. It'll just move to a different form. It'll move to the courts. That's not what happened on things like Medicare and Social Security. There was built a broad bipartisan consensus. In other words, members of Congress actually did the hard work to find that consensus so that they didn't have to hand it off to the judiciary. And unfortunately, I think we've seen a tendency in recent years to do exactly that, where Congress has abdicated its responsibilities, figuratively, let me say, pull the pin on a hand grenade and then hand it to the judiciary and say, you figure it out. And maybe, just maybe, that's one reason why these judicial confirmation hearings have become so contentious. because people actually see the judiciary as the ultimate policymaker. And as was quoted, I think, Justice Scalia talking about the value judgments of judges versus those of the citizenry or elected representatives. And he said that there's no reason to think that the value judgments of the judiciary are any better than those of the citizens that ultimately, in whom resides the ultimate legitimacy and political power. And of course, the most fundamental difference, I guess, between the job that you currently hold and the one that you will hold on the Supreme Court is the notion of accountability. As a judge, you serve for lifetime tenure, correct?
Correct.
You don't have to stand for election.
No.
You don't have to raise money.
No.
You don't have to consult polls,
No.
focus groups.
No.
Well, how in the world do you decide a case if you don't consult with public opinion, polls, focus groups, or the like?
Well, the reason we have life tenure as federal judges is to be insulated from the pressure that such things like focus groups or polls or public opinion might, the pressure that it might apply for a court to decide a case a particular way or the other. That's why we decided according to the text.
Well, and there are various rules of the road, so to speak, for how the judiciary approaches cases, right?
Correct?
In other words, perhaps the most fundamental difference is that rather than making broad policy pronouncements, you decide cases, correct?
That is correct.
And in fact, I'm struck by a New York University Law Review article by Justice Ginsburg in, I forgot what year it is, but where she talks about Roe versus Wade. And she talks about what she called the breathtaking decision versus the court's more cautious dispositions. She said, suppose the court had stopped after rightly declaring unconstitutional a portion of the law and had not gone on, as it did in Roe, to fashion a regime blanketing the subject, a set of rules that displaced virtually every state law that enforced. Would there have been a 20-year controversy we have witnessed, reflected most recently in the Supreme Court splinter decision in Planned Parenthood versus Casey? Might it have served to reduce rather than to fuel controversy? Well, I think what she's saying is when the courts step in and basically take over by stating a constitutional rule, it really prevents the very people who are elected by voters from making policy, correct?
Correct.
And there are a number of other things other than the requirement of a case or controversy that keep the judiciary in its appropriate lane. Things like standing requirement.
Yes.
What is standing?
Standing means that you can't just come to court, say, because you dislike Senator Graham's Fetal Pain Act. You can't just walk into the door of the courthouse and say, I don't like that act and I think it's unconstitutional. Standing means that you actually have to have suffered what the law calls a concrete injury, so it has to have affected you in some way. So that means that there are real litigants with a live controversy before the court. People can't come to court to air policy disagreements only.
And then there's a requirement of ripeness. What is ripeness?
Ripeness means that there has to be a live controversy. You can't run to the courthouse door and file a lawsuit until it's ripe, which means that the injury I was talking about has actually come to fruition, come to pass.
And of course, by the time you see it on the circuit court, the case has already had to have been tried by a trial court, correct?
That is correct.
And then there's a record, right?
Yes.
And what encompasses a record that the trial court prepares that you review as an appellate judge?
Well, there'll be factual parts of the record. So if there was a trial, there'll be very lengthy transcript of that trial. A district court makes a number of legal rulings in the course of a case. So the court may have ruled on, say, a motion to dismiss and whether the law even permitted this, whether the law gave the plaintiff a valid claim. The court may have ruled on a motion for summary judgment, which means that's an evaluation of whether the plaintiff or the defendant could win the case without even going through a full trial because the law was clear enough. So there are many things along the way. There are evidentiary rulings, legal rulings, a factual record that develops, and in some instances, it's quite long.
And as an appellate judge on the Seventh Circuit, you can't go outside the record, can you?
You can't. The record can't be expanded on appeal.
And that's true in the Supreme Court as well?
Yes.
And so all of these rules of the road, I'll call them, things like the case or controversy requirement, ripeness, standing, being confined to a record that is then the sole focus of an appellate review. Do all of those things, are all those sort of indications of how the judicial decision-making process is different from the legislative process?
Yes, and it can take years for a case to wind itself through that process. So as opposed to policymakers that don't have to wait on real parties and real disputes, and the parties get to shape the case their way, they get to decide what legal issues they're going to contest, and that narrows what the court can do. So policymakers, if you had, enough agreement to pass something, you could just do it in one day, just enact the law, enact the policy, and that is definitely not how judicial decision-making works.
Well, I know that you have followed the same rule as Justice Ginsburg in not expressing opinions on cases that might come before the court. Is this another practical reason why you can't predict how you will rule in the future? Because you don't know what the facts of that case may be. You don't know what the issues in controversy might be. So how in the world could you sit here and basically tell us about what your policy will be without knowing all of that?
I couldn't, and I think when Justice Ginsburg said it would show disregard for the judicial process and even disregard for litigants, what she was getting at is that it would signal to litigants, listen, all the briefs and stuff you file in a case, that doesn't really matter because judges just have a gut reaction. They just, they know what they think, and this is all just going through the motions. But that's not how the judicial process should work or does work.
There's no reason to believe that a judge's gut reaction is any better than any other American citizen's reaction, is there?
No, and the judicial process, I described this a little bit yesterday, a judge needs to have an open mind every step of the way. So as I said, I've changed my mind at oral argument even after reading the briefs. I've changed my mind at conference after consulting with my colleagues. So if I were to just say how I thought I would resolve a case just because I saw the issue, it would be short-circuiting that whole process through which I should go and have an open mind and be open to persuasion.
Well, I don't see any of the big blow-ups or charts here today about individuals that were the subject of the stories that our Democratic friends were telling yesterday. Maybe we'll see them later. But to me, the idea that some case that you might decide in the future that you have not had a chance to go through this analysis of and predicting how you might rule in the case, is that even possible?
It's not possible because I don't know whether my mind could be changed at some step along the way. And if I did it, I think I said yesterday, I'd be kind of like a legal pundit, just commenting on things in real time. And I don't think anyone wants judges to function that way. They want judges to go through the process, take things seriously, do a lot of research, do a lot of writing, keep an open mind.
And where in the Constitution does it authorize a judge to be a legal pundit and just make policy pronouncements separated from all of these requirements?
Well, Article 3 prohibits it, and so far as Article 3, the court has said prohibits federal courts from issuing what are called advisory opinions. And that means that when there's no real case in front of you, no real case or controversy, then you can't just offer an advisory opinion that's not the resolution of a case to express your view of the law.
So it's not fair, is it, to suggest that by confirming you to this position, you're somehow going to adversely impact the lives of these individuals?
Well, as I said yesterday, what I can say is that I have certainly no agenda. I'm not on a mission. I'm not hostile to the ACA at all. And if I were on the court and if a case involving the ACA came before me, I would approach it with an open mind, just like I do every case, and go through the process that we've just discussed.
And again, referring back to what Justice Ginsburg said in this New York University Law Review article, if judges restrict themselves to deciding cases or controversies as opposed to making broad policy announcements and displacing legitimate dispute, debate, negotiation, and legislation, does that encourage more litigation and dissension, or does it resolve it?
Well, without commenting on what Justice Ginsburg said about Roe versus Wade in particular,
No, I'm not talking about that. I'm talking about generally speaking.
just as a general matter, the case or controversy requirement, insofar as it ties the court to the particular litigants and to the particular issue presented in the case. In fact, the Supreme Court has a rule that it will not consider questions outside of the question presented in the case, absent unusual circumstances. And so that means that the court can't reach out and decide other issues that might be in the case if it didn't grant cert on them. And so I think incremental decision-making or a court limiting itself to the issues actually presented is one way that the court tries to respect this constraint on its power, that it's only actually resolving the cases right in front of it.
And getting back to the Declaration of Independence and the source of governmental legitimacy, this structure, these arrangements are not made to benefit you or the courts or to benefit us. They're to benefit the American people by making sure that they are the ones who are the source of political power. Do you agree with that?
All provisions in the Constitution are there to benefit the people.
And so if the court rules on a statute, we can change the statute, but if the court says something is unconstitutional, you could amend the Constitution to change that ruling. The people could do that, right?
Yes, they could.
So the American people are the final word.
Yes.
Mr. President, Mr. Chairman,
Thank you. Senator Durbin.
Thanks, Mr. Chairman. Judge Barrett, good to see you again.
Good morning.
Thank you. You're making history. You're the first, I wish the senator from Idaho could hear this, you are the first nominee for a vacancy on the Supreme Court to be considered after July 1st of the election year. In fact, you're the first nominee to ever be considered in the midst of an election. I don't know if that has ever happened before. It certainly hasn't in modern history. And the obvious question is why? What's the hurry? Why couldn't we wait till the end of November or December or even January after leaving a vacancy on the court for 10 months after Antonin Scalia's passing? Well, because there is a political agenda here. And whether you are privy to it, part of it, notwithstanding, it has to do with the Affordable Care Act. November 10th is the absolute date they have to fill the vacancy if the president and those who support him and those who support the Republican platform are going to keep their promise to end the Affordable Care Act. They need that ninth justice, and that's why it has to be hurried. Unfortunately, that is the cloud, the orange cloud over your nomination as it comes before us here in the Senate Judiciary Committee. And it raises many questions. I'd like to confine my first part of these questions to what's going on across America as we meet here today. There's an election going on. People are trying to vote. And there are a lot of issues out there that are being debated and somewhat resolved or unresolved every single day. The president continues to lie about paper ballots, saying that they are fraudulent, people shouldn't use them. There's still long lines, unforgivably long lines, for people who just want to exercise their right to vote, the governed who want to give their consent, Senator Cornyn. There's a battle royal over the Postal Service and whether it's going to be implicated in some effort to slow down or stop ballots from being delivered. One ballot collection box in Harris County, Texas, for more than 4 million people, one box. It's pretty clear what's going on here. It's an effort to make it difficult to vote, even for those who are legally entitled. Historically, the Republican Party is starting using a tactic of discouraging voters. We've seen this, making it more difficult, reducing the period of time that people can vote early, requiring IDs even if there's no evidence of fraud, purging the rolls of names. This is all going on. So I want to confine my questions at the outset here on the question of voting. And let me start with what many people read this morning, and I did, which was a summary of one of the exchanges yesterday here in the committee. It was Senator Feinstein, who said President Trump made claims of voter fraud and suggested he wanted to delay the upcoming election. Senator Feinstein then asked you, does the Constitution give the President of the United States the authority, listen closely to what she asked you, to unilaterally delay a general election under any circumstances? Does federal law? Your answer, well, Senator, if that question ever came before me, I would need to hear arguments from the litigants, read briefs and consult with my law clerks, talk to my colleagues, go through the opinion writing process. You went on to say you didn't want to give off-the-cuff answers like a pundit, but rather approach matters with an open mind. Is that still your response?
Senator, I've given that response to every hypothetical that I've been asked in the hearings. And as I said yesterday, I do that regardless whether it's easy or hard. I don't do that to try to, whether the question, would be easy or hard. I don't try to do that to signal it, but I do that because it would be inappropriate for me to make a comment. And I don't think I've answered any legal hypotheticals in keeping with the Justice Ginsburg rule.
So I guess what troubles me is this. You style yourself an originalist, textualist, factualist, whatever the term is, which means you go right to the words and try to understand the words in their original meaning. And so if I change Senator Feinstein's question and didn't ask you whether the president has the authority to unilaterally delay a general election, asked you instead, does the president have the authority to unilaterally deny the right to vote to any person based on their race? What would your answer be?
Well, Senator, obviously there are many laws in effect, including the Equal Protection Clause, which prohibits discrimination on the basis of race, including the 15th Amendment, which protects the right to vote against discrimination based on race. And so there's a principle in constitutional law called external constraints. And even if one evaluates what the authority a branch might have to act, there are external constraints that press in from other parts of the Constitution. Here, it would be the 14th and 15th Amendments.
Well, of course it would. The 15th Amendment, the right of citizens of the United States to vote shall not be denied or abridged by the United States or any state on account of race. For an originalist and a textualist, that is clear text as I see it. But when asked whether or not the president has any authority to unilaterally deny that right to vote for a person based on race or even gender, are you saying you can't answer that question?
Senator, I just referenced the 14th and 15th Amendments, the same one that you just repeated back to me, that do prohibit discrimination on the basis of race in voting. So as I said, I don't know how else I can say it, the Constitution contains provisions that prohibit discrimination on the basis of race in voting.
But whether a president can unilaterally deny, you're not going to answer yes or no.
Well, Senator, you've asked a couple different questions about what the president might be able to unilaterally do, and I think that I really can't say anything more than I'm not going to answer hypotheticals.
It strains originalism. If the clear wording of the Constitution establishes a right and you will not acknowledge it.
Well, Senator, it would strain the canons of conduct, which don't permit me to offer off-the-cuff reactions or any opinions outside of the judicial decision-making process. It would strain Article 3, which prevents me from deciding legal issues outside the context of cases and controversies, and as Justice Ginsburg said, it would display disregard for the whole judicial process.
So then let's take it to the case we've discussed before, Cantor versus Barr.
Okay?
Your 37-page dissent in this case. And yesterday, the junior senator from Missouri, in attempt to rehabilitate the witness, asked you, you never say that the right to vote is somewhat secondary or less than any other right. Is that fair to say? And you answered, yes, that is fair to say. I never said that. I have read and reread this. I'm not ready for a question on the final, but I've read and reread your dissent on this. I'd like to read to you what you wrote on this very question asked by the senator from Missouri. In sum, well, I think we need to establish what this case is about for those who may not know or remember. Ricky Cantor was a con man, lived in Wisconsin. He manufactured some kind of shoe insert, a pad, and tried to sell it to people who had diabetes or some foot problems. He wanted the Medicare to say that it was approved. They didn't. He sold it